early. Nobody's here.
Defer ng roll, defer ng journal. Pwede. May hab mo ba na? Kalabasan si Dom. Kasi nandito si Uging eh. Yes. Uging si Uging. Oh, nakita si Uging dito. Si Uging. Pag nagkalan.
Ah, okay, thanks.
Automatic pala. So what do you want to do? Defer natin roll. You want to do reference?
Hindi, wala pang minority. Ay, ito si... Pwede yung mag-reference, boss.
Basta na yung boss.
Thank you very much, boss.
Can someone interrupt during reading reference of business?
Well, at any point, they may, but it's not look well. Okay, defer mo muna ang roll call, approval, reference of business ka, tapos suspend.
Okay. Ikaw na, Chart. Sa'yo ngayon eh. Ano ba?
Open.
Defer na roll, defer approval, and reference of business tayo. Yun lang, suspend.
Kumusta ang majority caucus, boss? Yung pa. Ongoing pa.
Pero there was an amendment which everyone was okay with. Okay, yung save money. Di ba may mga mandatory testing? Everything. Seclusion perpetual. Lahat.
Motion na lahat. Inclusion perpetual.
Yung mandatory din.
Wala naman.
At least, kanina,
Pero merong iba. Merong
Dalawa siguro.
Shock nga po ulit. Mandatory
the
testing.
opportunity for the PDP,
Hello?
we need to see item by item.
Hello?
Well acquainted sila sa bill na yan.
Oo. Yes, sure.
SGMA nga. Oh. Sabi is GMA sila. Parang at least narinig niya from RP to RIP.
Sige.
Ongoing pa.
Ongoing pa. Hindi na ba kami wala ko lang. So,
Okay.
hindi pinagkat kay
Ang speaker.
siya.
Pinaglutuhan, isa-isa. Kanina sa 65, wala namang wala.
Si Bimbong nga pag ba na ako ng death penalty,
Retroactive. Retroactive.
Charge ko na.
Minority lang.
Pero, national anthem. Okay. The session is called to order. Please rise for the singing of the national anthem. Please remain standing for a minute of silent prayer. Majority Leader.
Madam Speaker, I move that we defer the calling of the roll.
Is there any objection? Hearing none, the motion is granted.
Madam Speaker, I move for the deferment of the approval of journals of the previous session.
Is there any objection? Hearing none, the motion is granted.
Madam Speaker, I move that we now proceed with the reference of business and request that the Secretary General be directed to read the titles of bills and resolutions on first readings, as well as communications and committee reports.
Is there an objection? Hearing none, the motion is granted. The Secretary General is directed to read the titles of bills and resolutions on first reading, as well as the communications and committee reports for referral to the appropriate committees.
Reference of business, bills on first reading. House Bill number 4904, amending Republic Act number 8178 by Representative Biap Arthur.
To the Committee on Agriculture and Food.
House Bill number 4905, amending Section 3 and to be of Republic Act 8794 by Representative Del Rosario.
To the Committee on Public Works and Highways.
House Bill number 4906, extending for another 25 years the franchise granted to the Delta Broadcasting System Incorporated by Representative Velasco.
To the Committee on Legislative Franchises.
House Bill number 4907 and 4908, separating, converting certain school extensions in Iloilo Province into an independent national high school by Representative Garin Oscar.
To the Committee on Basic Education and Culture.
House Bill 4909, establishing the month of August as the start of the academic year in all public schools in the Philippines by Representative Garin Oscar.
To the Committee on Basic Education and Culture.
House Bill number 4910 to 4913 and 4916 to 4920, converting various roads in Iloilo Province into national roads by Representative Garin Oscar.
To the Committee on Public Works and Highways.
House Bill 4914, creating a municipal trial court for the municipality of Tigbawan, Province of Iloilo by Representative Garin Oscar.
To the Committee on Justice.
House Bill 4915, naming the Iloilo City Dumangas Coastal Road as Congressman Narciso Dolar Monfort Highway by Representative Garin Oscar.
To the Committee on Public Works and Highways.
House Bill number 4921, amending certain provision of Republic Act 9593 by Representative Pichay.
To the Committee on Tourism.
House Bill 4922, requiring the implementation by brand owners of management plans that provide refund values for certain beverage containers by Representative Rocamora.
To the Committee on Ecology.
House Bill 4926, establishing the Philippine High School for the Arts, Siargao by Representative Matugas.
To the Committee on Basic Education and Culture.
House Bill 4928, strengthening union organization and disallowing cancellation of union registration by Representative Mendoza.
To the Committee on Labor and Employment.
House Bill 4929, promoting the welfare of workers in the wellness spa, beauty salon, fitness gym, and related business by facilitating them membership in the SSS by Representative Mendoza.
To the Committee on Government, Enterprises, and Privatization.
House Bill 4930, increasing the separation pay of employees terminated due to disease by Representative Mendoza.
To the Committee on Labor and Employment.
House Bill 4931, instituting workers' claim as statutory first line on the asset of the bankrupt employer by Representative Mendoza.
To the Committee on Labor and Employment.
House Bill 4932, protecting employees in cases of merger or consolidation, sale or transfer of all or substantially all assets or businesses of their employers by Representative Mendoza.
To the Committee on Labor and Employment.
House Bill 4933, fixing the probationary period of employment of academic personnel in private schools by Representative Mendoza.
To the Committee on Labor and Employment.
House Bill 4936, establishing the Litan National High School in Barangay Litan, Gipo, Zamboanga del Sur by Representative Ceriles.
To the Committee on Basic Education and Culture.
House Bill 4939, exempting Philippine sea salt from mandatory iodization by Representative Salo and Lacson.
To the Committee on Health.
House Bill 4945, amending Batas Pambansa Bilang 517 by converting the Labuan Public Hospital in Zamboanga City into a Level 2 General Hospital by Representative Lobrigat.
To the Committee on Health.
Resolutions. House Resolution 740, congratulating and commending Wesley So, Philippine-born 23-year-old Grandmaster, for winning the world's strongest chess tournament, the Tata Steel Chess Tournament 79th edition, and ranking world number 2 in the process by Representative Castelo.
To the Committee on Youth and Sports Development.
House Resolution 741, urging the Committee on Public Order and Safety to investigate the intelligence gathered by the Defense Secretary indicating the establishment by the international terrorist group Islamic State of a base of Wilayat province in central Mindanao by Representative Castelo.
To the Committee on Rules.
House Resolution 742, congratulating and commending Agnes Jacusalem, a 51-year-old Filipina, for being the first Filipina ever to be crowned Miss Grandma Universe 2017 in a pageant held in Sofia, Bulgaria on January 22, 2017 by Representative Castello.
To the Committee on Rules.
House Resolution 743, commending the exemplary efforts of the DOT, PNP, AFP, and other government agencies that led to the successful holding of the Miss Universe pageant in our country by Representative Alejano.
To the Committee on Rules.
House Resolution 744, calling for an investigation on how local government units give exemption from payment of local taxes to certain corporations by Representative Atienza.
To the Committee on Rules.
House Resolution 745, condemning the recent attacks made by the NPA while a mutually declared unilateral ceasefire is in place, and to urge both the government of the Republic of the Philippines and the Communist Party of the Philippines New People's Army, National Democratic Front, to continue with the peace talks in order to preserve the gains of the peace process and to resolve the hindrances in attaining a just and lasting peace in the country by Representative Alejano.
To the Special Committee on Peace, Reconciliation, and Unity.
Committee report number 101 by the Committee on Women and Gender Equality on House Bill 4982.
To the Committee on Rules. Majority Leader.
Madam Speaker, I move for the change of referral of the following measures. House Bill number 1200, establishing lighthouses in all coastal areas in the Philippines, from the Committee on Public Works and Highways to the Committee on Transportation. House Bill number 1203, from the Committee on Public Works and Highways to the Committee on Transportation. House Bill number 479, from the Committee on Public Works and Highways to the Committee on Government Enterprises and Privatization and Public Works and Highways. House Bill number 703, from the Committee on Public Works and Highways to the Committee on Government Enterprises and Privatization. House Bill number 2075, from the Committee on Public Works and Highways to the Committee on Government Enterprises and Privatization. House Bill number 2496, from the Committee on Poverty Alleviation to the Special Committee on Food Security. House Resolution number 294, from the Committee on Public Works and Highways to the Committee on Government Enterprises and Privatization and Public Works and Highways. So moved, Madam Speaker.
Is there any objection? Hearing none, the motion for the change of referral of the measures so mentioned is hereby approved.
Madam Speaker, in accordance with our rules governing inquiries in aid of legislation, I move that we refer the following House resolutions to the appropriate committees. H.R. 705 to the Committee on Ecology. H.R. 706 to the Committee on Higher and Technical Education and Transportation. H.R. 707 to the Committee on Higher and Technical Education and Transportation. H.R. 709 to the Committee on Ecology. H.R. 710 to the Committee on Trade and Industry. H.R. 714 to the Committee on Metro Manila Development. H.R. 715 to the Committee on Games and Amusements. H.R. 720 to the Committee on Public Order and Safety. So moved, Madam Speaker.
Is there an objection? Hearing none, the motion is approved.
Madam Speaker, in accordance with our rules governing inquiries in aid of legislation, I move that we refer the following House resolutions to the appropriate committees. H.R. 721 to the Committee on National Defense and Security. H.R. 722 to the Committee on Higher and Technical Education. H.R. 723 to the Committee on Transportation. H.R. 724 to the Committee on National Defense and Security. H.R. 725 to the Committee on Agriculture and Food. H.R. 726 to the Committee on Public Order and Safety. H.R. 727 to the Committee on Public Order and Safety. H.R. 728 to the Committee on Transportation. So move, Madam Speaker.
Is there an objection? Hearing none, the motion is approved.
Madam Speaker, I move for the suspension of session for a few minutes.
Session suspended. Session is resumed. Okay.
No sound.
Okay na.
Tinapos mo doon. So, kanina ako lang nag-open.
Suspend.
Suspend.
Okay. Session is resumed.
Madam Speaker, I move that we call the roll of members.
Is there any objection? Hearing none, the motion is approved. The Secretary General is directed to call the roll of members.
Roll call of members, honorable representatives. Abad, Abaya, Abayon, Abellanosa, Abu, Abueg, Acharon, Akop, Acosta, Acosta Alba, Adjong, Advincula, Agrao, Agabaw, Aglipay Villar,
I move that we consider House Bill 477
Albano,
and direct the Secretary General to read the title of the bill. Then after this,
Alcala,
the parliamentary status of the bill is in the
Alejano,
sponsorship and debate.
Almario, Almonte, Alonte Nagiat, Alvarez Franz, Alvarez Mercedes, Alvarez Pantaleon,
Yeah, with the parliamentary status is A.
Amante,
Then you
Amatong,
recognize the sponsor and recognize the interpellation.
Andaya, Angara Castillo,
Of sponsorship,
Antonino,
way of interpellation.
Antonio, Aragones, Arbison, Arcillas, Arenas, Atienza, Aumentado, Bagaw, Bagaching, Bagilat, Banal, Barbers, Barsaga, Batawil, Batocabe, Bautista Bandigan, Belaro, Belmonte Feliciano, Belmonte Jose Christopher, Belmonte Ricardo, Benitez, Bernos, Bertis, Biason, Billones, Biron, Bulilia, Bondok, Bordado, Bravo Anthony, Bravo Marabida, Brosas, Bulot Pigtang, Cagas, Calderon, Calixto Rubiano, Caminero, Campos, Kanama, Kari, Casilaw, Castelo, Castro Franz, Castro Fredenil, Katamko, Cayetano, Celeste, Serafica, Cirilles, Chavez, Chupeco, Cuanco, Culiantes, Cortés, Cortuna, Cosalan, Crisólogo, Cuba, Cuaresma, Cueva, Delipe, Dalog, Dasa, De Jesus, De Venecia, De Vera, Defensor, Del Mar, Del Rosario, De Losa Montalia, Di Maporo Abdullah, Di Maporo Khalid, Duavit, Durano, Di, Elago, Enverga, Erice, Erigel, Ermita Buain, Escudero, Espina, Espino, Estrella, Eusebio, Ivardone, Fariñas, Fernando, Ferrer Juliet, Ferrer Luis, Ferriol, Floyrendo, Flores, Fortuno, Ventebelia, Garbin, Garcia Gwendolyn, Garcia Jose, Garcia Albano, Gary Richard, Gary Sharon, Gasataya, Gachelian, Heron, Goana Cristina, Gomark, Gomez, Gonzaga, Gonzales Alexandria, Gonzales Aurelio Dong, Gonzales Fernando, Goriseta, Gulyas, Hernandez, Herrera D, Hofer, Halusos, Javier, Konghun, Labad-Labad, Lacson, Lagman, Lanete, Laugan, Lasatin, Liachon, Lee, Lim Kay Chong, Lobrigat, Lopez Benhur, Lopez Carlo, Lopez Manuel, Loyola, Macapagal-Arroyo, Maceda, Madrona, Malapitan, Manalo, Mangawang, Magudodato Suarto, Magudodato Sajid, Marcoleta, Marcos, Mariño, Marquez, Martinez, Matugas, Miliana, Mending, Mendoza, Mercado, Mirasol, Montoro, Nava, Nieto, Noel, Nograles Jericho, Nograles Carlo, Nolasco, Nunez Manañaon, Waminal, Ocampo, Olivares, Ong Edwin, Ong Henry, Ortega Pablo, Ortega Vini, Pacquiao, Paduano, Palma, Pancho, Panganiban, Panotes, Papandayan, Pichay, Pimentel, Pineda, Plaza, Primicia Sagabas, Kimbo, Radasa, Ramirez Sato, Ramos, Relampagos, Revilla, Roapuno, Robes, Rocamora, Rodriguez Isidro, Rodriguez Maximo, Roman, Romero, Romualdez, Romualdo, Roque Hari, Roque Rogelio, Sakdalan, Sagarbaria, Sali, Salceda, Salimbangon, Salo, Salon, Sambar, Sandoval, Santos Recto, Sarmiento Cesar, Sarmiento Edgar, Sevillano, Sema, Xiao, Silverio, Singson, Swansing Estrelita, Swansing Horacio, Suarez, Si Alvarado, Tambunting, Tan Angelina, Tan Milagrosa, Tan Shady, Tejada, Teves, Chanco, Ting, Tiño, Tolentino, Treñas, Tugna, Tupas, Turabi Nataman, Ti, Umali, Unabia, Ungab, Unico, Uy Juliet, Uy Rolando, Uy Bareta, Vargas, Vargas Alfonso, Velarde, Velasco, Velasco Catera, Veloso, Vergara, Villapuerte, Villanueva, Villarasa Suárez, Villarica, Villarin, Vilago, Yap Artur, Yap Melesio, Yap Victor, Yu, Samora Mar Carmen, Samora Ronaldo, Sarate, Subiri. Madam Speaker, the roll call shows that 215 members responded to the call.
With 215 members responding to the call, the chair declares the presence of a quorum.
Mr. Speaker.
Madam Speaker, I move that we
Yes.
consider House
Mr.
Bill
Speaker.
4727 as embodied in
Mr.
Committee
Speaker.
Report number 47.
Privilege.
So
motion.
moved, Madam Speaker, Your
Mr.
Honor.
Speaker, Privilege
Congressman
motion.
Atienza, yes, sir.
please respect the rights of every member in this chamber. Magkakasundo-sundo tayo pagka may respeto kayo pinakikita. I would like to point out, Madam Speaker,
Yes.
the Secretariat again declared a 215 attendance. There are only 192 on the floor. I would like to believe that you respect the rules of the House as we would want to respect the rules of the House. But if you keep on adding presence of members who are not around, that constitutes by itself is a violation of our rules. Huwag po sanang ganyan. Meron po naman quorum eh. Sobra-sobra eh. 147 lang pong quorum natin. Respeto ang tawag dyan. Oh? So we call the attention of the Secretariat once again. We want to put it on record that you would like to entertain a made-up number of members present. It is not correct. Hindi po yan ang katotohanan. Ang katotohanan, 192 responded to the roll call. Thank you.
Thank you, Congressman Atienza. Majority Leader.
Madam Speaker, I reiterate my previous motion for the consideration of House Bill 4727. Could the Secretary General be directed to read the title of same? So move, Madam Speaker, Your Honor.
Is there an objection? Hearing none, the Secretary General is so directed.
House Bill number 4727, an act imposing the death penalty on certain heinous crimes, repealing for the purpose Republic Act number 9346, entitled an act prohibiting the imposition of death penalty in the Philippines and amending Act number 3815 as amended, otherwise known as the Revised Penal Code and other special penal laws.
Majority Leader.
Madam Speaker, Your Honor, I move for the recognition of the sponsor of the measure, the Honorable Chairman of the Committee on Justice, our colleague, the Honorable Reynaldo Umali. So move, Madam Speaker, Your Honor.
Is there an objection? Hearing none, Congressman Umali is recognized.
Good afternoon, Madam Speaker, ladies and gentlemen. We have already completed our sponsorship speech, and now we are ready for the interpellation of the members.
Madam Speaker, for his interpellation of the Honorable Sponsor, I move for the recognition of the gentleman from the 1st District of Albay, the Honorable Edsel Lagman. So move, Madam Speaker, Your Honor.
The Honorable Edsel Lagman is recognized.
Thank you, Madam Speaker. As we have previously requested in writing and verbally, the majority leader, we are going to preface our interpellation with an overview of the grounds which are advocated by the opponents of the bill against the death penalty reimposition. Mr. Speaker, the burden to indubitably and conclusively show the urgency and necessity to reimpose the death penalty is on the proponents of House Bill 4727, which seeks to revive capital punishment because the state of the law since 2006 is that the death penalty has been abolished by Republic Act number 9346, of which I was the principal author and sponsor. The oppositors respectfully and diligently present the overview of the major grounds why the death penalty should not be reinstalled. While no time is ripe for pushing for the reimposition of the death penalty, now is the worst of times to enact the revival of capital punishment when scalawag cops are the very felons and rogues in robes preside over the life or death of citizens. In an unprecedented move, President Rodrigo Duterte has ordered the crackdown on errant police elements and the dismantling of anti-narcotics groups including Oplan Tokhan, in the wake of the police murder of a Korean businessman. Not to mention over 7,000 victims of extrajudicial killings. On the other hand, no less than Supreme Court Chief Justice Lourdes Sereno has revealed very recently that between 2012 and 2016, 16 judges and one Sandigan Bayan justice were dismissed for acts unbecoming of officers in the judiciary. She added that in the same period, the Supreme Court suspended 14 judges, fined 101, reprimanded 21, and admonished 31. The High Court also dismissed 116 court employees, admonished 42, forfeited benefits of 31, censured 3, fined 240, reprimanded 221, and suspended 227 since 2010. Madam Speaker, distinguished colleagues, justice is not only delayed, but also wantonly waylaid due to the flawed, inept, and corrupt police, prosecutorial, and judicial systems, the very pillars of our judicial system. We must put the death penalty bill irretrievably in the back burner and address and implement with dispatch much delayed reforms in the police and justice system. No less than Committee on Justice Chair, the Honorable Reynaldo O'Malley, advocated the same pressing reforms in his sponsorship speech several or many times. Madam Speaker, distinguished colleagues, it will not make the revival of the death penalty less retrogressive and repugnant to the inviolability of life if it is imposed solely on drug-related offenses. In fact, the Philippines is a state party to the 1988 UN Drug Convention, which prescribes only imprisonment, not death, to drug-related offenses. This is our treaty commitment. Let me repeat this, Madam Speaker. In fact, the Philippines is a state party to the 1988 UN Drug Convention, which prescribes only imprisonment, not death, to drug-related offenses. Capital punishment must not be revived for any crime for the following overriding reasons. One, the reimposition of the death penalty will not solve criminality, including the drug menace. Solving the incidence of crime is a multi-dimensional process which ranges from sustained poverty alleviation to much-needed police, prosecutorial, and judicial reforms. The severest penalty is not the antidote to criminality. Number two, pronounced social injustice, crippling poverty, and the utter absence of quality of life among the disadvantaged and marginalized sectors are among the root causes of criminality. The data are irrefutable that it is in the poorest of regions and countries where the incidence of criminality is highest. We should address with utmost priority the critical causes of criminality, not only its manifestation. Number three, the death penalty desecrates the right to life, which is sacrosanct and inviolable, and it is an affront to human dignity. Pope Francis instructs in his message to the 6th World Congress Against the Death Penalty in Oslo, Norway, last year, 2006, that the inviolability of life extends to the criminal. No amount of out-of-context invocation of the Bible will diminish the Pope's steadfast opposition to the death penalty. More than anybody else, Madam Speaker, Pope Francis is the final authority on the interpretation of the Bible. In this case, we cannot literally be more papist than the Pope. It is for this reason that bereaved families of countless victims of so-called heinous crimes do not wish death to the perpetrators. The families of victims of enforced disappearance or desaparecidos, like my own family, who lost a member, Attorney Herman Lagman, a labor and human rights lawyer, to involuntary disappearance committed by elements of martial law. My family and I also do not want death for the assassins of my brother, Pilemon Kapopoy Lagman, who was gunned down in the UP campus 16 years ago on February 6, 2001. There are many more like-minded families who want genuine justice, not short-lived retribution. Number 4, empirical data from the Philippines and worldwide document that the death penalty through the years has not been an effective deterrent to crime. What deters the commission of crimes are certainty of apprehension, speedy prosecution, and warranted conviction. Number 5, the death penalty exacerbates the culture of violence, and its revival adds state-sanctioned killings to the unabated extrajudicial killings related to the deadly campaign against the drug menace. Number 6, the death penalty cannot be prioritized over the long-delayed reforms in our broad police, prosecutorial, and judicial systems, which make genuine justice illusory to the majority of our people. The infirmities in our pillars of justice do not only delay, but also worse, waylay justice as well. 7, the death penalty further marginalizes and victimizes the poor, who can neither retain competent counsel nor influence court processes. The unassailable data is that the poor overly populate death rows worldwide. This is the same data in the new beloved prisons death row before the death penalty was abolished in 2006 by Republic Act number 9346. Number 8, capital punishment enforces punitive and retributive justice instead of promoting the modern concept of penology on restorative justice, which aims to reform the convict and prepare his eventual reintegration into society. Pope Francis again extolled that, quote, "There is no fitting punishment without hope. Punishment for its own sake, without room for hope, is a form of torture, not punishment," unquote. Hence, the death penalty, which forecloses reformation of the convict, must not be imposed because, according to Pope Francis, It does not render justice to the victims, but instead fosters vengeance. Vengeance is not justice, distinguished colleagues. Number 9, the revival of the death penalty utterly fails to consider that human justice is fallible, and even the innocent can be executed. The Supreme Court has repeatedly enjoined that, and I quote, courts should be guided by the principle that it would be better to set free 10 men who might be probably guilty of the crime charged than convict one innocent man for a crime he did not commit, unquote. The records show that countless persons are sentenced to death for crimes they have not committed. Madam Speaker, distinguished colleagues, the fact that many death sentences are reversed anyway upon automatic review by the Supreme Court is not a proper argument for the reimposition of the death penalty. It overlooks the irreparable trauma of a victim, the irreparable trauma of a convict and his family while waiting the final decision on his death sentence. In fact, Commissioner Joaquin Bernas, during the Constitutional Commission deliberations, clearly stated that, and I quote, capital punishment is inhuman for the convict and his family who are traumatized by the waiting, even if it is never carried out, unquote. The 1987 Constitution does not prescribe the death penalty. On the other hand, it abolishes the death penalty, although the Congress is allowed to reimpose it for compelling reasons on heinous crimes. The Congress has no plenary or absolute power to restore the death penalty. Its limited power is circumscribed by the Constitution, which requires two overriding conditions: A, compelling reasons, and B, heinous crimes. Section 9 of Article 3 of the Constitution on the Bill of Rights provides that, and I quote, neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. The Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. The heinousness of a crime is not determinative of the compelling reasons for imposing the death penalty. They are not synonymous. Heinousness is not a compelling reason. Congress must show and prove separately the determinant factors of heinousness and compelling reasons. Isolated and sporadic sensational or sensationalized crimes like chop-chop, placing the victim inside a barrel, and inordinate cruelty inflicted on the victims are not compelling reasons to reimpose the death penalty. The isolated occurrence of one or two of these once-in-a-blue-moon crimes do not constitute a compelling reason to reinstall capital punishment as required by the Constitution. Calls for the death penalty after the random commission of such so-called heinous crimes are mere knee-jerk reactions from the mob. However, the perpetrators of occasional sensational crimes are blinded. Moreover, the perpetrators of occasional sensational crimes are blinded by spontaneous fury due to supervening temporary derangement of the mind. While they should be imprisoned, they need professional psychiatric help, not execution. 11. However, as a state party to the International Covenant on Civil and Political Rights, or the ICCPR, and the second optional protocol to the ICCPR, the Philippines is committed to abolish the death penalty and not to reimpose it. The Philippines ratified the ICCR in 1986 before the 1987 Constitution abolished the death penalty. And the second optional protocol was ratified by the Philippines in 2007 after the abolition of the death penalty under Republic Act 9346. Perforce by our treaty commitments, the Philippines has abandoned the option to revive the death penalty. These treaty obligations, as accepted principles of international law, form part of Philippine law, primarily of the Constitution. International conventions and jurisprudence provide that a country cannot assert its domestic law or constitution to negate or violate its treaty obligations. Let me repeat that, Madam Speaker. International conventions and jurisprudence provide that a country cannot assert its domestic law or constitution to negate or violate its treaty obligations. International jurisprudence mandates that, as, and I quote, an integral part of the community of nations, we are responsible to assure that our government, constitution, and laws will carry out our international obligations. Hence, we cannot readily plead the Constitution as a convenient excuse for non-compliance with our obligations, duties, and responsibilities under international law. This is the same well-anchored opinion advocated by the late Senator Jubito Salonga, together with the late former Chief Justice Pedro Yap, and their book, Public International Law. Moreover, Article 13 of the Declaration of Rights and Duties of States, adopted by the International Law Convention in 1949, provides every state has the duty to carry out in good faith its obligations arising from treaties and other sources of international law, and it may not invoke provision in its constitution or in its laws as an excuse for failure to perform this duty, unquote. Equally important is Article 26 of the Convention, which provides that, and I quote, every treaty in force is binding upon the parties to it and must be performed by them in good faith. This is known as the principle of pacta sunt servanda, which preserves the sanctity of treaties and has been one of the most fundamental principles of positive international law, supported by jurisprudence of international tribunals. It is on record that no state party to the second optional protocol to the ICCR has reimposed the death penalty in its jurisdiction. The Philippines may be lamentably and dishonorably be the unfortunate first. 12. There are serious economic repercussions if the Philippines reimposes the death penalty, as we would lose free tariff privileges on our exports to European Union countries which require adherence to human rights. We will forfeit tariff privileges for 6,274 products under the Generalized System of Preferences, or GSP+. Moreover, a reimposition of the death penalty will compound human rights violations due to rampant extrajudicial killings, which the European Union has already protested. 13. With the revival of the death penalty, the Philippines would lose moral ascendancy in negotiating for the lifting of the death sentences on Filipino OFWs numbering over 70 worldwide. Because of President Duterte's position to reimpose the death penalty, the Philippine government was unable to strongly plea to save the life of Jakatya Pawa, a death convict in Kuwait, who maintained her innocence to her last breath. 14. The irreversible trend is the diminishing number of countries imposing the death penalty. Out of 195 countries documented by the United Nations, only 37 retain the death penalty in both law and practice. Only 4 countries, China, Iran, Pakistan, and Saudi Arabia, account for 90% of the executions. 15. If the death penalty is reimposed, the Philippines will lose its preeminent leadership in the ASEAN and in the Asian region in the crusade for the promotion of human rights. The Philippines was the first Asian country to abolish the death penalty. Members of ASEAN Parliamentarians for Human Rights, APHR, urged President Duterte and Philippine legislators to immediately desist in their pursuit of a reinstatement of the death penalty, calling on them to respect the Philippines' international obligations and avoid undermining the country's much-respected role as a regional leader on human rights protection. The APHR underscored that, and I quote, "It would be an incredible setback to our collective struggle if the Philippines were to take the dramatic step backward of reinstating the death penalty. The move would not only indicate a rejection of hard-fought progress, but would cause other ASEAN nations to question the Philippines' commitment to the full gamut of international treaties it has signed," the APHR stressed. The authors of HB number 4727 have not shown indubitable, compelling reasons for the reimposition of the death penalty compliant with the Constitution. The alleged rising criminality cannot be a compelling reason for the reimposition of the death penalty for 2 cardinal reasons. A, granting that there is an increase in the incidence of crime, such increase has different socioeconomic causes, not the mere propensity of people to commit crimes. These major causes cannot be addressed and arrested by just imposing the death penalty. And B, the claim of increasing crime rate is not true. No less than the Philippine National Police has recently documented that the incidence of crime has gone down, except for murder due to the rampant extrajudicial killings committed by the police themselves and their vigilante cohorts. The same statistics have been cited by the chairman of the Committee on Justice in his sponsorship speech. Madam Speaker, distinguished colleagues, in there can be no compelling reason at all to abrogate the right to life. In a survey released only on 31 January 2017, the SWS has reported that the number of Filipinos who have been victims of crimes in the last 6 months fell to record lows, with only 4.5% of the respondents claiming that they have fallen prey to street robbery, carjacking, and break-ins, compared to 5.5% in March and June 2015 and 6.4% in September 2016. We must consign to the past the trio of instruments of death: lethal injection, hanging, and firing squad. The first is a modern method of execution which has failed in several instances to administer a painless and instant death, while the latter two are vestiges of archaic apparatuses of death. We must perforce reject House Bill number 4727 and put to death an unwarranted exercise of reviving the death penalty. We must save from the death penalty the lives of common as well as admirable citizens like Socrates, Jesus Christ, and our own national hero, Jose Rizal, who were all innocent of the crimes for which they were charged, but were sacrificed to state-sanctioned violence and vengeance. Finally, Madam Speaker, distinguished colleagues, it would be good to keep in mind a Chinese proverb which reminds us that he who seeks vengeance must dig two graves, one for his enemy and one for himself, because justice is not vengeance, and vengeance is not justice. Thank you, Madam Speaker. I would be ready now to make my interpellation. It would be an interpellation which may not be too long, because I would defer to Representative Raul Del Mar, who was the first one who registered to interpellate. But may I request for a few minutes of recess?
Session suspended.
I will start my interpellation. Then later I would defer to Raul Del Mar. No, to Raul Del Mar. Kasi siya na unang nag-register. Nag-request lang ako sa kanya na paunahin niya ako. Then I would resume my interpellation after Del Mar. Or after the next interpellation. Hindi, simula na ako. Meron po dito.
Sessions resumed. Majority Leader.
Madam Speaker, our parliamentary status is that we are in consideration of House Bill number 4727. The Honorable Sponsor, the Honorable Umali, is recognized. Interpellating him is the Honorable Edsel Lagman.
Congressman Umali as sponsor and to interpellate Congressman Lagman are hereby recognized.
Madam Speaker, will the distinguished chairman of the Committee on Justice yield to a few questions?
With pleasure, Madam Speaker.
In the Philippine jurisdiction, the rule under the 1987 Constitution is that the death penalty is abolished. Is that correct?
That is not so, Madam Speaker, Your Honor, because the Constitution, the 1987 Constitution, precisely states that death penalty can be reimposed for compelling reasons for heinous crimes. So that, in effect, does not abolish the death penalty.
Madam Speaker, I'm asking for the rule, and the distinguished chairman is talking about the exception. But let us first agree on the rule. But I heard that the distinguished chairman said that the death penalty has not been abolished by the 1987 Constitution. Did I hear him right?
That is correct. What was, and if I may just read Section 19, Article 3 of the Constitution, excessive fine shall not be imposed, nor cruel or degrading or inhuman punishment inflicted. So this is the main rule, while it says that neither shall death penalty be imposed unless for compelling reasons involving heinous crimes, Congress may hereafter provide it. So the death penalty was not totally abolished, for the Constitution itself provided for an exception for its imposition.
Does the distinguished gentleman posit that the Constitution prescribes the death penalty?
It does not prescribe the death penalty, but it allows an exception to it when, for compelling reasons, heinous crimes, compelling reasons involving heinous crimes.
When there is an exception, Madam Speaker, there must be a general rule. And the general rule in our jurisprudence, in our jurisdiction, under the 1987 Constitution, is that the death penalty has been abolished. The Constitution is very clear. Neither shall death penalty be imposed. That is the rule. We can go to the exception later.
That is not entirely correct. I don't subscribe to that proposition, Your Honors, Madam Speaker, because you should read the full text of the Constitution. You should read the constitutional provision, and you cannot delimit the interpretation simply on the phrase "neither shall death penalty be imposed," because the Constitution itself provides for the exception. So there was no total abolition. It may have been abolished for certain crimes, but it did not delimit Congress to reimpose it for compelling reasons, and these are for cases involving heinous crimes.
Madam Speaker, the Constitution on Article 3 on the Bill of Rights provides for a general rule and also prescribes an exception. The rule is that the death penalty is abolished. As a matter of fact, from 1987 to 1993, was the death penalty imposed in our jurisdiction? Madam Speaker, distinguished Chairman?
Yes, Madam Speaker. To my own understanding, that what the general rule says is that death penalty shall not be imposed. And that is not synonymous to abolition of death penalty. The non-imposition cannot be considered abolition because it provides for certain exceptions. So how can we say that it was abolished when the Constitution merely says that it shall not be imposed unless for compelling reasons involving heinous crimes?
When a penalty is not imposed, it is equal to its abolition. Madam Speaker, distinguished Chairman, that's why I asked the question from 1987 to 1993, was the death penalty imposed in the Philippines? Was the death penalty considered the capital penalty in the Philippines?
May I, I'm sorry, I did not get the question. What is the question, Madam Speaker, Your Honor?
From the ratification of the 1987 Constitution to 1993, when the death penalty was reimposed, was there any execution by death in the Philippines?
There was none, Madam Speaker.
There was none because the death penalty had been abolished. It was only in 1993 when it was revived.
That is not correct. What we are saying is that the general rule says that it shall not be imposed, and so it was not imposed. But then, in 1993, as pointed out by the gentleman from Albay, it was reimposed, and in fact, it was carried out, and the Supreme Court, in the case of People versus Echegaray, even provided the reasons why death penalty should be imposed. At any rate, Madam Speaker, I would also like to invite the attention of my esteemed colleague on the Bill of Rights, Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. And if you will, if I may just quote our good majority leader, this is a negative presentation of the Bill of Rights. If you look at it in a positive light, if you say it in a positive light, persons may be deprived of, or persons shall be deprived of life, liberty, or property with due process of law. So it is the same Constitution that says that persons may be deprived of life, liberty, or property. And therefore, if you will look at these two provisions, you cannot look at it singly by saying death penalty has been abolished.
Mr. Speaker, we will go to that other constitutional provision. We are just engaged with respect to Section 9, Article 1, Section 9, 1 of Article 3 of the Constitution. But you check all of this jurisprudence, decisions of the Supreme Court, including the dissenting opinion of former Justice Panganiban. They all confirm that the 1987 Constitution abolished the death penalty, but provided for an exception. And the exception is Congress may reimpose the death penalty for compelling reasons involving heinous crimes. Now, when a law or the Constitution provides for exceptions, what is the rule on construction or interpretation? Is it liberal or strict?
It must be interpreted in accordance with its letter. And the letter says that there is an exception, and therefore, death penalty was not abolished. To my mind and to my legal mind, I guess I would like to think that death penalty was only suspended, because after 86, when death penalty was suspended, this was restored again, and this was reimposed again in 1993, as you mentioned, and so this was carried until it was again suspended in 2006 through a law that was passed by Congress.
Well, the jurisprudence is that with respect to exceptions, whether statutory or constitutional, they should be subjected to strict construction or interpretation. That is the prevailing jurisprudence in our country. Now, if the death penalty was not abolished, what are you going to restore? That's why we are restoring the death penalty, because it was abolished by the 1987 Constitution. And there is an exception that Congress may revive the death penalty for compelling reasons involving heinous crimes. In other words, Congress has no plenary or absolute power to restore the death penalty. The power of Congress is limited, and limited by two overriding conditions. May we know what are these two overriding conditions, distinguished Chairman?
Before I answer that, let me just rebut those points on statutory construction. My own understanding of the rule on statutory construction is that when the law or the provision of the Constitution is clear, it leaves no room for any interpretation. And secondly, on the point of what is there to restore when it was not abolished, as I was saying, the death penalty was merely suspended. So when you suspend something, then you can restore a law, and that, as a matter of fact, it was restored in 1993, as in fact there was a convict who was executed and was convicted by death. And so this is just semantics that we're talking about. And so I would like to go now to the point or the query of what is the compelling reason for the reimposition of death penalty.
My question,
and I have pointed for compelling reasons that made me decide that we should reimpose death through this bill that we are now discussing in the halls of Congress.
The answer, Your Honor, of the distinguished chairman is not responsive to my question. My question is, what are the two overriding conditions prescribed by the Constitution so that Congress can restore, revive the death penalty?
2 points, Your Honor, Madam Speaker. One is the need for a compelling reason, and I have mentioned 4, and the other one is heinous crimes, and these are the things that we have listed in the bill that are now for deliberation by this August chamber.
Incidentally, Madam Speaker, for purposes of jurisprudence, I would show to the distinguished gentleman, it's in my folder, that the prevailing jurisprudence is that exceptions provided by law or the Constitution must be construed strictly against the exception. It is not a question of clarity or dubiousness of the provision. It's a question of a rule of construction between liberal and strict construction. While the law itself is liberally construed, the exception to the law. While the Constitution is liberally construed, the exception provided by the Constitution must be strictly construed or interpreted. Now, consequently, Congress, in reviving the death penalty, must strictly comply with the overriding conditions of 1, compelling reasons. It does not say reason only, but compelling reasons, and 2, heinous crimes. Are the two synonymous?
No, they are separate. They are two things that we should consider. And the Committee on Justice had considered that in our deliberations. We found that there are compelling reasons as follows. Death penalty is a fitting response to increasing criminality and killings in the country. 2, death penalty is a measure to restore respect for the laws of the land. And third is death penalty as a path to achieving justice, and death penalty, the reimposition of death penalty is geared towards a genuine reform in the Philippine criminal justice system. So I'm not talking only of 1 compelling reason. I talked of 4 compelling reasons. And if you will ask us about heinous crimes, we have listed 21 heinous crimes, starting from treason, qualified piracy, qualified bribery, parricide, murder, infanticide, rape, aggravated qualified rape, kidnapping and serious illegal detention, robbery with violence against or intimidation of persons, destructive arson, plunder, importation of dangerous drugs, sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and or controlled precursors and essential chemicals, maintenance of den, dive, or resort, manufacture of dangerous drugs and or controlled precursors and essential chemicals, possession of dangerous drugs, cultivation or culture of plants classified as dangerous drugs or as sources thereof, unlawful prescription of dangerous drugs, misappropriation, misapplication, or failure to account confiscated, seize, surrender dangerous drugs, planting of evidence, carnapping. These are the heinous crimes that we have identified, we have discussed extensively in the subcommittee meetings that were conducted for the purpose and which we are now deliberating on. So these are 2 different things that we considered, the Justice Committee had considered in the various hearings that we conducted.
In other words, Madam Speaker, distinguished sponsor, compelling reasons and heinousness of the crime are concurrent conditions to be complied with as prescribed by the Constitution. They are not synonymous, they are separate, they are concurrent. Is that correct?
Yes, that is correct.
And the existence of a heinous crime is not determinative of compelling reason. Is that correct?
The compelling reasons go beyond the crimes itself. That's why we mentioned 4 compelling reasons for the reimposition of death penalty, and that is the increasing criminality and the gravity of the killings, the gravity of the crimes being committed, and the lack of respect for the laws of the land of the country by our own nationals, unlike when they are in different parts of this world, they exhibit the kind of discipline in honoring the laws of the lands where they are in. But unfortunately, in this country, we seem to violate any and all rules that we can find because criminals feel that they can get away with the crimes, they can buy their way to freedom, or they can even buy justice. And these are the reasons why we would like to reimpose death penalty.
But in other words, to my simple question, the heinousness of a crime is not determinative of a compelling reason. Is that correct?
No, that is one of the requirements of the Constitution, that crimes, that the reimposition of death penalty must be for heinous crimes. And so, we have considered that in the committee, and we have all the reasons to give why we feel that there is compelling reason why death penalty must be reimposed for heinous crimes as required by the Constitution.
Madam Speaker, with due respect to the distinguished sponsor, his answer is not responsive and evasive. My only question, my simple question, is the heinousness of a crime determinative of compelling reason? Yes or no?
It is not solely the heinousness of the crime that is the compelling reason. There are other more compelling reasons. The drug proliferation in this country, that is also a reason why we are imposing death penalty for drug-related heinous crimes.
When the distinguished sponsor says, Madam Speaker, that the heinousness of the crime is not solely determinative of compelling reason, is it partly determinative?
Definitely. Definitely, because the crimes being committed of late are so heinous, so gruesome, shocking to the conscience of any peace-loving citizen. And this is one of the reasons why we need to reimpose death penalty.
That is the basic flaw in the arguments of the proponents, because they try to mix up heinousness with compelling reason. After the distinguished sponsor said that compelling reasons and heinousness are separate conditions and they are concurrent, Now he says that heinousness could be partly determinative of compelling reasons, which is completely against the prescription of the Constitution and against the jurisprudence that exceptions must be strictly construed. Now, the distinguished sponsor cited 4 alleged grounds which he claims are compelling reasons. They are, according to him, the death penalty is a fitting response to increasing criminality and killings in the country. That is number 1. We have already debunked this because the increasing criminality is not a compelling reason because there are other grounds other than the propensity to commit crime which would cause an increase in the crime rate and crime volume. But the more important argument against this is that no less than the data presented by the chairman of the Committee on Justice said that according to the PNP data, the crime rate and crime volume has decreased except for murder. Is that correct, Your Honor?
That is correct. There was a decrease of, to my recollection, about 40% of the crimes being committed other than murder.
In other words, if we follow the logic of the distinguished sponsor, it is only with respect to the incidence of murder that the crime rate has increased. And so, if we still follow logically his statement, it is only with respect to murder that there is a compelling reason to revive the death penalty. Is that correct?
That is not so, because other related crimes were committed which resulted to murder. So, or which resulted to death. And like rape and the like. And this is the reason why we also included all of the other heinous crimes in the offenses to be covered by House Bill 4727.
Well, with respect to rape, what is the data of the PNP? Did it increase or decrease in volume and rate?
I do not have the data. My colleagues will provide this information. Honorable Ching Veloso and Deputy Speaker Fred Castro, who will respond to this. But perhaps let us go to the compelling reasons minus the statistics which will be provided by the other sponsors.
But statistics are very important, Your Honor.
I know.
No less than the chairman cited statistics in his sponsorship speech. May I know whether there is a rising criminality in rate and volume with respect to piracy?
There is none that I know of on qualified piracy.
Is there an increasing rate of criminality with respect to treason?
I am not aware of any at this point in time that this offense had or the courts had tried anyone for treason.
Is there an increasing rate of criminality with respect to destructive arson?
I would like to think so. There are many arson cases that were committed in the past several years.
No, we are asking for data.
That is why
we are not asking for the opinion of the distinguished chairman, because his opinion may contradict the data, the statistics. That's why we are asking for data. Is the distinguished chairman ready to present the data?
PNP data shows that from 1993 to 1998, there was a decrease in crimes, but starting 2001 up to the present, there was an increase in the index crimes and non-index crimes, and especially in 2008, Madam Speaker, Your Honor.
But 2008, Madam Speaker, is how many years ago? We want to have fresh data, current data, not antiquated data.
Based on PNP report, Madam Speaker, from 2012 up to 2015, non-index crimes rose from 88,651 to 474,803. On the other hand, from 2012 to 2013, there was increase in the index crime from 129,000 to 370,000. But there was a decrease in 2015 down to 201,000. 2016 is a different story altogether.
In other words, we are enacting the revival of the death penalty when there is a decrease in the crime rate and volume, except for murder. Of course, murder will be accepted because of the extrajudicial killings involving police elements and vigilantes who are the cohorts of police officers. But may I ask the distinguished gentleman, if murder per se is a heinous crime, pursuant to the deliberations of the Constitutional Convention,
it will, Madam Speaker, Your Honor, murder in itself will require many other considerations for the reimposition of death penalty. In fact, when we reimpose death penalty, this is not an automatic reimposition of death penalty because this will go through a process. And the judge or even the justice of the Supreme Court who will conduct an automatic review may or may not reimpose, may not impose death penalty. For it may, they may also impose reclusion perpetua. But anyway, in the deliberations of the 1987 Constitution, Mr. Monsod, Commissioner Monsod, Commissioner Monsod, who is a member of that Constitutional Commission, had identified dope distribution, dope smuggling, organized murder, brutal murder of rape victim as examples of heinous crimes.
Your Honor, we are only asking with respect to murder. What was the deliberation of the Constitutional Commission with respect to murder? Not with respect to other crimes. Let us go one by one so that we could intelligently discuss the issue. What was the opinion of Commissioner Monsod with respect to murder being a heinous crime?
As I said, Madam Speaker, Commissioner Monsod cited as examples organized murder, brutal murder of rape victim as examples of heinous crimes. If the good, my esteemed colleague would like to limit it to murder.
There is what is important. In the proceedings of the Constitutional Convention, murder by itself was not categorized as heinous. What was categorized as heinous was organized murder. May we know from the distinguished gentleman what is the data on the rate of criminality as well as the volume of criminality with respect to organized murder?
You know, these were statements of constitutional commissioners at that point in time. And the time, that was in 1987. And times have changed. There was an evolution of the gravity of how murder is committed so that we cannot limit ourselves to organized crime. Precisely, we are here in the halls of Congress to determine that. And during the committee deliberations, these are the things that we considered for purposes of including murder as a heinous crime, as one of the crimes that we included for purposes of the reimposition of death penalty, because we noted that for the period, I think July to January 2016, there was a rise in the crime of on murder as a crime by 51%.
Again, the answer of the distinguished sponsor is not responsive. My question is, what is the data on the rate of criminality or volume of criminality with respect to organized murder?
Well, Madam Speaker, as I said, organized murder can be interpreted in so many ways. Like, for example, the killing of G.Ik Ju. I would like to look at it and consider it as organized murder because there was even involvement of police and NBI officials reportedly, which came out in the course of the investigation of Senate, which conducted an inquiry on this. And there are many sorts of cases that happen on organized murder. I do not have the specific data on how many these are. I do not have the exact definition of organized murder, and that is the reason why I cannot directly answer my esteemed colleague, the gentleman from Albay, on what is the data on organized murder.
In other words, instead of meandering to sensationalize crimes or once-in-a-blue moon offenses like the murder of the Korean businessman, I think the distinguished chairman should be candid enough that they do not have the data on the crime rates with respect to organized murder. Is that correct?
I'm sure we have the data, and as I mentioned, my colleagues will provide those informations. But then again, we are witnesses to the many crimes that are happening in our country for the longest time. Since the time that death penalty was suspended from 2006 up to the present time. Our newspapers, the news will also carry all sorts of crimes being committed, which are gruesome, which are heinous, and I'm sure that my esteemed colleague is well aware of all of these crimes that are happening that we see in the newspapers, that we read in our newspapers and see in our television. So, delving on specific numbers is really something that escapes me because I have mentioned about the crime trend from 2001 up to 2015. I mentioned about data on index crimes and killings which happened for a certain period of time. And these are daily happenings that we read in our papers and we see on television.
Well, we are not debating on heinousness of crimes. We are on the compelling reasons. But if the distinguished gentleman says that the data we want is still forthcoming because they have it, but it's not with him, then we might as well suspend the consideration of House Bill number 4727 until the distinguished gentleman has the data we are asking for. I move therefore
with all due respect,
I move
Madam
therefore
Speaker.
for the suspension of the consideration of House Bill number 4727 pending the submission or availability of
If
said
I may,
data.
Madam Speaker, I would like just to point out that regardless of statistics, Congress is only limited to reimpose death penalty for compelling reasons involving heinous crimes. Even the cases, even Supreme Court in that case, anong kaso yun? Even the Supreme Court in People versus Echegaray states the imposition of the requirement that there be a rise in incidents of criminality because of the suspension of the death penalty is unfair and a misplaced demand for what it amounts to. In fact, is a requirement that death penalty first prove itself to be a truly deterrent factor in criminal behavior. If there was a dramatically higher incidence of criminality during the time that the death penalty was suspended, that would have proven that death penalty was indeed a deterrent during the years before its suspension. Suffice it to say that the Constitution in the first place did not require that death penalty be first proven to be a deterrent. What it requires is that there be a compelling reason involving heinous crimes. So this was the gist of the Supreme Court decision in People versus Echegaray, and may I repeat that these data are no requirement needed to be able to pursue our deliberation and our debate on the reimposition of death penalty.
Madam Speaker, I have a pending motion to suspend consideration of House Bill number 4727 in the absence of the data we were requesting, because there will be other data we are going to request.
Majority Leader.
Madam Speaker, Your Honor, the need for data by a single member does not preclude us from debating the measure at hand. So that forces us to oppose the motion of the Honorable Lagman.
In the face of the opposition of the acting majority leader, let me pursue my questions. With respect to the crime rate, does the sponsoring committee have any data on the criminality rate before the abolition or non-imposition of the death penalty by the 1987 Constitution?
I think, Madam Speaker, I've already answered that these data and statistics are no requirement. These are not preconditions for a continuing debate on the matter. Again, let me cite another portion of the case of People versus Echegaray. And I quote, "It is immaterial and irrelevant that RA number 7659 cites that there has been an alarming upsurge of such crimes, for the same was never intended by said law to be the yardstick to determine the existence of compelling reasons involving heinous crimes. Fittingly, thus, what RA 7659 states is that the Congress, in the interest of justice, public order, and rule of law, and the need to rationalize and harmonize the penal sanctions for heinous crimes, finds compelling reason to impose the death penalty for said crimes." And I have forwarded 4 compelling reasons for the reimposition of death penalty, Madam Speaker.
Madam Speaker, with the kind indulgence of the two gentlemen on the floor, they are discussing the most important and most critical issue of the 17th Congress, possibly. Right now, they are now talking about data and records. We would like to listen to them more, as we would like to help settle these issues, very important and relevant to the matter. But we do not have enough members on the floor anymore. We do not have a quorum, Madam Speaker. We would rather continue the interpellation on a better day where there is more in attendance at marami po tayong maririnig. Words of wisdom to from the two gentlemen. We move for a calling of the roll to establish a quorum. Otherwise, we shall move for adjournment.
Majority Leader.
Madam Speaker, we second the motion to call the roll of members. So moved, Madam Speaker, Your Honor.
The Secretary General is directed to call the roll of members.
Alin, iayos ko yung buwan mo.
Roll call of members, honorable representatives. Abad. Abaya. Abayon. Abillanosa. Abu. Abueg. Acharon. Akop. Acosta. Acosta Alba. Adjong. Advincula. Agaraw. Agabaw. Aglipay Bilyar. Albano, Alcala, Alejano, Almario, Almonte, Alonte Nagiat, Alvarez Franz, Alvarez Mercedes, Alvarez Pantaleon, Amante, Amatong, Andaya, Angara Castillo, Antonino, Antonio, Aragones, Arbizon, Arcillas, Arenas, Atienza, Aumentado, Bagaw, Bagaching, Bagilat, Banal, Barbers, Barsaga, Batawil, Batucabe, Bautista Bandigan, Belaro, Belmonte Feliciano, Belmonte Jose Christopher, Belmonte Ricardo, Benitez, Bernos, Bertis, Biason, Billones, Biron, Bulilia, Bundok, Bordado, Bravo Anthony, Bravo Maravida, Brosas, Bulot Bigtang, Cagas, Calderon, Calixto Rubiano, Caminero, Campos, Kanama, Kari, Casilaw, Castelo, Caso Franz, Caso Fredenil, Katamko, Cayetano, Celeste, Serafica, Cirilles, Chavez, Chipeco, Ko, Cuanco, Culliantes, Cortés, Cortuna, Cosalan, Crisólogo, Cuba, Cuaresma, Cueva, Dalipe, Dalog, Dasa, De Jesus, De Venecia, De Vera, Defensor, Del Mar, Del Rosario, De Los Montalia, Dimaporo Abdullah, Dimaporo Khalid, Duavit, Durano, D. Ilago, Enverga, Erice, Erigel, Ermita Buain, Escudero, Espina, Espino, Estrella, Eusebio, Ibardone, Fariñas, Fernando, Ferrer Juliet, Ferrer Luis, Friol, Floyrendo, Flores, Fortuno, Fuentebella, Garbin, Garcia Gwendolyn, Garcia Jose, Garcia Albano, Gary Richard, Gary Sharon, Gasataya, Gachelian, Heron, Guana Cristina, Gomark, Gomez, Gonzaga, Gonzales Alexandria, Gonzales Aurelio Dong, Gonzales Fernando, Goriseta, Gulias, Hernández, Herrera D, Hofer, Alosos, Javier, Ko, Konghun, Labad-Labad, Lacson, Lagman, Lanete, Laugan, Lasatin, Liachon, Lee, Lim Kay Chong, Lobrigat, Lopez Benur, Lopez Carlo, Lopez Manuel, Loyola, Macapagal Arroyo, Maceda, Madrona, Malapitan, Manalo, Mangawang, Magudodato Suarto, Magudodato Sajid, Marcoleta, Marcos, Mariño, Marquez, Martinez, Matugas, Miliana, Mending, Mendoza, Mercado, Mirasol, Montoro, Nava, Nieto, Noel, Nograles Jericho, Nograles Carlo, Nolasco, Nunez Malignaon, Waminal, Ocampo, Olivares, Ong Edwin, Ong Henry, Ortega Pablo, Ortega Vini, Pacquiao, Paduano, Palma, Pancho, Panganiban, Panotes, Papandayan, Pichay, Pimentel, Pineda, Plaza, Primicia Sagabas, Kimbo, Radasa, Ramirez Sato, Ramos, Relampagos, Revilla, Roa Puno, Robes, Rocamora, Rodriguez Isidro, Rodriguez Maximo, Roman, Romero, Romualdez, Romualdo, Roque Hari, Roque Roelio, Sakdalan, Sagarbaria, Sahali, Salceda, Salimbangon, Salo, Salon, Sambar, Sandoval, Santos Recto, Sarmiento Cesar, Sarmiento Edgar, Sevillano, Sema, Xiao, Silverio, Singson, Swansig Estrelita, Swansig Horacio, Suarez, si Alvarado, Tambunting, Tan Angelina, Tan Milagrosa, Tan Shirley, Teada, Teves, Chanco, Ting, Tiño, Tolentino, Treñas, Tugna, Tupas, Turabi na Taman, T, Umali, Unabia, Ungab, Unico, Uy Juliet, Uy Rolando, Uy Barreta, Vargas, Vargas Alfonso, Velarde, Velasco, Velasco Catera, Veloso, Vergara, Villaperte, Villanueva, Villarasa Suarez, Villarica, Villarin, Villago, Yap Arthur, Yap Melesio, Yap Victor, Yu, Samora Mar Carmen, Samora Ronaldo, Sarate, Subiri.
Most recent. Madam Speaker, we're waiting for the count of the Secretariat.
Yes, we would like to request that the majority leader be given some time to verify the figures too?
Well, we are waiting. As we have waited 1 hour before we even started.
Yes, if you
session
would be
today.
so kind as to also wait, I'm requesting.
We
for
will
the-
wait until kingdom come.
Yes. Certainly, Congressman.
Yes, we have a very effective, accommodating, for the record, majority leader. But we must also assist him do a good job. And what we're doing actually is for the whole Congress, not for ourselves. So please, do not admonish us to give more support for the majority leader. We support him fully. But the count is the count. We must have a result of the roll call.
Madam Speaker, the roll call shows that 156 members responded to the call.
Madam Speaker.
With 156 members responding to the call,
Madam
the Chair
Speaker.
declares the presence of a quorum.
Yes, we're questioning again the count of the Secretariat because our count, which is accurately done from the gallery, shows we only have 135 on the floor. We do not have a quorum. We are lacking 12 members. Just for the record, we are saying that this session, if it resumes, is doing its job out of order.
Majority Leader.
Yes, ma'am. That is the point of the gentleman, but our official count is 156. We have quorum. May we proceed with the interpellation?
Yes. Kindly proceed with the interpellation, Majority Leader.
Madam Speaker, our parliamentary status, we are in consideration of House Bill 4727. I move for the recognition of the honorable sponsor, Chairman Reynaldo Umali, and our colleague interpellating him, the Honorable Edsel Lagman. So move, Madam Speaker.
Congressman Umali and Congressman Nagman are recognized.
Madam Speaker, before there was a roll call with a long-delayed announcement of the result, the distinguished sponsor was quoting from the decision of the Supreme Court in Leo versus Echegaray. May we ask the distinguished sponsor to quote again what he mentioned, because we did not get the essence of the quotation.
May I request for a 1-minute suspension? We're just trying to locate this particular document.
Madam Speaker, I move for 1-minute suspension.
Session suspended.
There will be time for everybody unless you want to have a closure. Siyempre, hindi pa ako tapos sa portion ko eh. Hindi pa ako tapos sa number one na reason niya for compelling reason.
Boss, yun nga, they want to enforce the rule that speakers have to speak for more than an hour.
They said public record. Hindi na pa ako nagpapasuspend because they don't have the data. Ayaw nila i-suspend, it was my motion. After Raul. He just quoted it ngayon, hindi niya naman. Labas-labas. Dapat pala.
Ready na? Ready?
Session resumed. Session resumed.
Thank you, Madam Speaker. I was asked to quote again pertinent portions of the decision of the Supreme Court in the case of Leo Echegaray, which appears in page 19, fifth paragraph, in the middle of said paragraph, and I quote, "It is immaterial and irrelevant that RA 7659 cites that there has been an alarming upsurge of crimes, for the same was never intended by said law to be the yardstick to determine the existence of compelling reasons involving heinous crimes. Fittingly, thus, what RA 7659 states is that the Congress, in the interest of justice, public order, and rule of law, and the need to rationalize and harmonize the penal sanctions for heinous crimes, finds compelling reasons to impose the death penalty for said crimes." End of quote.
Well, Madam Speaker, distinguished sponsor, the essence of that quotation is that escalating criminality is not a compelling reason to impose the death penalty. And that precise quotation from Leo versus Echegaray would debunk the first argument of the distinguished sponsor, citing the death penalty is a fitting response to the increasing criminality in killings in the country. That was completely, the increase in criminality was completely negated by the Supreme Court as a compelling reason. So, the first compelling reason advanced by the distinguished sponsor should be struck down for being even inconsistent with the ruling of the Supreme Court in Leo versus Echegaray.
I beg to disagree, Madam Speaker, Your Honors. In fact, as I was saying, what we are talking about is data. And when there is this demand by my esteemed colleague for data, this is what we're saying, that this is not even necessary. What is important for me, as I earlier mentioned, is the daily occurrence that we witness every day in our lives for the longest time of how crimes are being committed left and right, and this affects this affects me first and foremost, and I think this should affect each and every one of us in this August Hall, because we cannot close our eyes to this criminality and the gravity of the crimes being committed nowadays. That is why this is the reason why we are saying that we need to reimpose death penalty. Even law enforcement officers or uniformed people are involved in crimes. What more compelling reason do we want when we citizens, peace-loving citizens, cannot even already trust even our law enforcers to do what they're so mandated to do to protect and secure the citizens from many of these crimes. These are sins of the past that ought to be responded to. These are sins of the past that we need to now correct to be able to really restore civility and restore respect for the rule of law and the laws of the land of this country.
Again, Madam Speaker, the distinguished sponsor, his answer is off-tangent to my observation. I was just synthesizing what he quoted from the decision in Leo versus Sagaray, that escalating criminality is not a compelling reason to reimpose the death penalty. But if he insists that it is, then I would say that increasing criminality would not depend on media headlines or the observation of the distinguished sponsor. It would depend on data.
Well, I can only respect the position of my esteemed colleague, but I do not share his position. And to my mind, even the other case that the other citation that I quoted, which says that the imposition of the requirement that there be a rise in incidents of criminality because of the suspension of the death penalty is an unfair and misplaced demand. For what it amounts to, in fact, is a requirement that death penalty first prove itself to be a truly deterrent factor in criminal behavior. So we are just talking here of data, but the fact of the matter is that the gravity also of the offense is something that is already shocking to the conscience of peace-loving citizens that had moved the Committee on Justice, and to my understanding, this is why the President had put it on top of his priority, because of the drug problem and the many other reasons that are happening in the country that had compelled us to approve this bill in the Committee on Justice. And now that we are seeking approval also from this August chamber.
May I remind the distinguished interpellator of Section 91 of our rules regarding time limit. Members shall not be allowed to speak for more than 1 hour in debate on any question. No member shall speak more than once on the same question without leave of the House unless the member is the proponent of the motion or has introduced the question or the matter pending, in which case the member shall be permitted to speak and reply, but not until every member who chooses to speak on the pending question or matter shall have spoken. May I request the distinguished interpellator to wind up his interpellation?
Madam Speaker, I have not spoken for more than 1 hour in my interpellation. I would appeal to the records of the House on the minutes I have consumed, because in counting the 1 hour, we should not include the time utilized by the sponsor. My questions are short, but the answers of the sponsor are inordinately long. So my 1 hour has not been consumed. I appeal to the records of the House.
Again,
Because
Madam
the
Chair,
transcription would show the minutes I have consumed.
if I may, Madam Speaker, I would like to take exception to that statement of my esteemed colleague that my answers are inordinately long. My answers are precise and concise. And I did not spend more than 30 minutes to respond to these questions.
Well,
Thank you. This is merely a reminder
yeah,
to
but,
the distinguished interpellator.
this should be a precedent that the time of the interpellator should be limited to the minutes he has consumed in posing his questions. And it should not include the time consumed by the sponsor answering the questions.
Noted. Distinguished interpellator.
Madam Speaker, may I raise this as a
Majority
point
Leader.
of order? Section 91, time limit, a member shall not be allowed to speak for more than 1 hour in debate on any question. The clock shows that the honorable interpellator has taken 1 hour and 32 minutes rather than let his proposal become a precedent. I raise this point of order that he has consumed already time beyond the time limit. Madam Speaker, Your Honor.
Noted.
The point of order is unwarranted because that is not the reckoning. The clock is not the reckoning of the time I have consumed. It should be the transcription which should tell us how many minutes I have consumed. But if the leadership of the House would like to gag me, then they can do that.
Madam Speaker, Your Honor, we ask for a ruling.
Yes. Yes. The point of order is well taken.
I appeal the ruling of the chair because I have not consumed 1 hour, Madam Speaker. But let us consult the transcription because the transcription would have the timing of how many minutes a speaker has consumed. And pending that
Before the
validation,
gentleman begins his appeal, Madam Speaker.
I still have the floor.
Madam Speaker, an appeal may be made and may be granted by the chair subject to 5 minutes. So please, could we reset the clock? Should you so grant the appeal?
The appeal is granted. The gentleman has 5 minutes.
Madam Speaker, the transcription section where there is a time indication of the minutes consumed by a speaker would show that I have not consumed 1 hour. Even in our proceedings before the committees, the time limitation is pegged on the time consumed by the member of the House making the interpellation or questions. I am certain if we consult the transcription section, I have the consumed 1 hour. And the time consumed by the sponsor responding to my question should not be used against me, Your Honor. Because my time should only be limited to the portion I have consumed in my interpellation. Verily, I have not consumed 1 hour.
Madam Speaker,
Majority Leader.
the gentleman is finished with his 5 minutes. Our parliamentary status is the majority leader raised a point of order invoking Section 91, which the chair upheld as in order. The gentleman appealed the ruling of the chair. He has explained his appeal. Now, we will now vote on the appeal. So,
before
guidance, for the guidance of the members, a vote of yes on the appeal, or I, will uphold the appeal. So a vote of nay will deny the appeal.
Madam
As
Speaker,
many as are in favor,
Madam
please
Speaker,
say aye.
Madam Speaker,
All those against,
Madam
please say
Speaker,
nay.
Madam Speaker,
The nays have it. The appeal is lost.
we have not.
Madam Speaker, you did not
Majority Leader.
Madam Speaker, I move for the recognition of the Honorable Gentleman from the 1st District of Cebu City, the Honorable Raul Del Mar, for his interpellation of the Honorable Sponsor. So moved, Madam Speaker, Your Honor.
The Honorable Del Mar is recognized for his interpellation.
Madam Speaker, before the voting, I was raising a point, but I was not recognized. And I would assume that when we had the voting, there was no more quorum in the House. And the action of the House is unwarranted.
The Honorable Del Mar has been recognized for his interpellation. Honorable Del Mar, please proceed.
Before we proceed, this representation is requesting for another vote, because when you asked for the vote for the affirmative, there was a discussion going on the floor. You did not hear the correct vote. So could we be allowed to vote again?
The Honorable Del Mar has the floor.
Madam Speaker, I am asking for an answer. If you deny it, you deny it, and we will take it. But do not disregard a question from the floor from a member of this Congress. You are not presiding according to the rules.
Honorable Del Mar, please proceed.
Yes, Madam Speaker, I'm just allowing a member his opportunity to question the chair or the majority leader. If it's true, then I can begin. But if there's a pending motion from the gentleman from Manila, then I should not start, because I would just be disturbed. When I start, I don't want to be disturbed.
May we state our...
There is no pending motion, Honorable Del Mar. Kindly proceed. You have been recognized.
Madam Speaker, we're again appealing for a fair rulings coming from the chair. Wala po namang masama, sigurado tayo sa ating botohan dito. Hindi po ito discretionary, hindi po ito personalan. We are appealing that a vote be called again, because on the time you called for a vote for the aye votes, there was a discussion going on. We were not able to vote. So we're appealing. If you deny it, you deny it right away, and we would take it. But we would always consider that as an abuse of your authority.
Madam Speaker,
Majority Leader.
I beg to disagree with the gentleman. Before the voting, I stated the parliamentary status that we were voting on the appeal, and the motion was clearly stated by the chair, and we voted. So it's already a done and disposed motion. And the gentleman is recognized. If the gentleman does not wish to interpellate, then we can proceed to the next interpellator on the list. But the chair has recognized the gentleman from Cebu. May we know if the gentleman of Cebu will avail of the period to interpellate or not, Madam Speaker?
Of course,
Honorable Delmar.
I will avail of my
Please
turn
proceed.
to interpellate.
Please proceed.
Thank you, Madam Speaker. Thank you, Majority Leader. Consistent with my position as co-author of the present law, Republic Act Number 9346, prohibiting the imposition of the death penalty enacted June 20, 2006, principally authored by the Honorable Edsel Lagman, I am against Subject House Bill number 4727, seeking to reimpose the death penalty on certain heinous crimes, repealing RA number 9346 and amending Act number 3815 as amended, otherwise known as the Revised Penal Code and other special laws. I likewise join the overview earlier given by Honorable Lacman, presenting practically all the principal reasons against the subject measure. However, I would like to expound on some of these reasons. But before I do, let me just very briefly set the tone of my interpellation by quoting a few lines of the message of Pope Francis to the World Coalition Against the Death Penalty meeting in Oslo, Norway, when he said, and I quote, "The death penalty is unacceptable, however grave the crime of the convicted person. It is an offense to the inviolability of life and to the dignity of the human person. It likewise contradicts God's plan for individuals and society and His merciful justice. Nor is it consonant with any just purpose of punishment. It does not render justice to victims, but instead fosters vengeance. The commandment, 'Thou shalt not kill,' has absolute value and applies both to the innocent and to the guilty." May I now, end of quote, may I now request the distinguished sponsor, if, Madam Speaker, if he will yield to some clarificatory questions from this representation.
Gladly, Madam Speaker. I will take some of the questions initially, and then I will request that the Honorable Ching Veloso, Congressman Ching Veloso, be recognized to continue with the sponsorship and to answer this interpellation question.
Thank you, distinguished sponsor, Chairman of the Committee on Justice. Let me again go straight to the present constitutional provision in question, which is the meat of the matter, the heart of this bill. And it has been quoted, and let me just read it again. Article 3, Bill of Rights, Section 19, Paragraph 1, which provides that excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. The Congress hereafter provides for it, and any death penalty already imposed shall be reduced to reclusion perpetua. Isn't it therefore clear, Your Honor, Mr. Speaker, that from the foregoing phrase, neither shall death penalty be imposed unless for compelling reasons involving heinous crimes, that for the death penalty to be imposed, it must be for heinous crimes, and that there must also be compelling reasons involving these heinous crimes, so that conversely, it means that Congress cannot stop at spelling out what heinous crimes are, but also point to the compelling reasons involving these heinous crimes.
That is correct, Madam Speaker, Your Honor.
Okay, let's take the first requirement again of heinous crimes. Section 3, first paragraph of subject bill defines crimes as heinous for being grievous, odious, and hateful offenses, which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized, and ordered society. Perhaps because this definition does not clearly describe what is meant by heinous crimes, a second paragraph was added thereto, enumerating certain crimes already punishable by reclusion perpetua or life imprisonment under Act Number 3815 as amended, otherwise known as the Revised Penal Code, and other special laws for the purpose of imposing the death penalty. The enumeration starts in page 2 of this bill and ends at page 16, covering all 15 pages of the bill consisting of 18 pages. However, the definition of these enumerated various crimes were merely copied, Mr. Speaker, Your Honor, from the Revised Penal Code that I quoted and the special penal laws, without any changes at all, except an amendment of their penalties from reclusion perpetua or life imprisonment to the penalty of death, which death penalty is now used merely as the basis for categorizing these crimes as heinous crimes. Is that correct, Mr. Speaker, Your Honor?
First, I'd like to explain that the definition here under Section 3 is that which is adopted from the decision of the Supreme Court, which clearly defined what a heinous crime is. So this is with jurisprudential moorings, Mr. Speaker. Now on the matter of the succeeding sentence and paragraphs which enumerated the heinous crimes, these are all heinous crime, or these are all crimes that are punishable by reclusion perpetua. Now, if you will go through the specific provisions, I do not know how you will argue against the gravity of this particular crimes enumerated, like, for example, treason. Any Filipino citizen who levies war against the Philippines or adheres to her enemies, giving them aid or comfort within the Philippines or elsewhere, shall be punished by reclusion perpetua to death, and shall, etc., etc. And so, this is a matter that is addressed to the conscience again of every Filipino who would commit acts of treason against his own country and against his own people by giving aid and comfort to the enemies of the state. So we included this because we feel that this is gruesome enough and shocking enough that it should be included as one of the heinous crimes that ought to be included for purposes of reimposing death penalty.
Distinguished sponsor, Mr. Speaker, was there any explanation or description or definition whatsoever why each of these crimes enumerated are categorized as heinous?
Madam Speaker, at this juncture, this was the subcommittee on judicial reforms that conducted as many hearings as there could be and passed this particular provision. So may I now ask that the Honorable Congressman Ching Veloso, be recognized.
Yes, the Honorable Ching Veloso is recognized.
Madam Speaker, during our meetings, the provisions in sections 4 to section 22 were described by the authors of the various bills as grievous, odious, and hateful offenses. They are inherently and manifestly wicked, vicious, atrocious, perverse, to the point that they are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized, and ordered society, Madam Speaker. The gentleman may ask this representation questions on why the committee agreed that those enumerated from sections 4 to section 22 were considered as heinous crimes.
Mr. Speaker, Your Honor, I don't completely fathom, nor do I agree, that there should be just a generic explanation. It must be clearly defined and described. And the definition should be not collective to apply to all these 21 crimes enumerated. There should be a definition and description for each and every crime enumerated. Isn't that correct, Your Honor, Mr. Speaker?
Madam Speaker, the ruling of the Supreme Court in the case of People versus Chikaray, February 7, 1997, pointed out that the 1987 Constitution did not abolish, but merely suspended death penalty. Because death penalty was merely suspended, it comes to reason, Madam Speaker, that, and in fact that was the reason why the Republic Act 7659 was passed in 1993. Now, of course, in 2006, this Republic Act 6759 was repealed. And now, House Bill 4727 attempts to have this reinstated. It does not require, Your Honor, if we take a look at Section 19, Paragraph 1, Article 3 of the Constitution, that we enumerate the surrounding circumstances by which a particular provision in the revised penal code that has been reinstated may be considered as a heinous crime. Again, sections 4 to 22 merely reinstated what have been suspended as a result of the 2006 repeal of Republic Act 7659.
I beg to disagree with the sponsor, my cousin from Leyte, the Honorable Veloso, because that was already discussed adequately by the Honorable Lagman and the Honorable Umali as to whether the death penalty was abolished or merely suspended.
I cannot disagree with the Supreme Court when it said that the death penalty was merely suspended in the case of Itchagaray. I suggest, Madam Speaker, that the Honorable Del Mar, which is a brilliant lawyer, just go through the discussions of the Supreme Court from that provision, or from that portion of the decision where the Supreme Court narrated the historical background of Section 19, Paragraph 1 of Article 3, which brought about the provision, excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment, or the death penalty inflicted. Death penalty already imposed shall be commuted to reclusion perpetua. This was the original proposal of Father Bernas. And then later, in the deliberations at the Constitutional Commission, Commissioner Napoleon J. Rama pointed out that, quote, never in our history has there been a higher incidence of crime, and that, quote, criminality was at its zenith during the last decade. This observation of Commissioner Rama was joined by other commissioners, including Commissioner Christian Munsod. I even would point out, Madam Speaker, that Bishop Bacani, in answer to the interpellation of Mr. Padilla, admitted that far from the Catholic point of view, the right of the state is not forbidden to impose death penalty. Again, I do not have to belabor, Your Honor. This matter, death penalty having been suspended, was included in the answer of the Honorable Umali to the interpellation of Honorable Laguan. And Honorable Umali pointed out a reading from the case of Ichigaray, which I will repeat, Madam Speaker. The imposition of the requirement that there be a rise in the incidence of criminality because of the suspension of the death penalty. It did not say because of the abolition. Because of the suspension of the death penalty, moreover, is unfair and a misplaced demand, for what it amounts to, in fact, is a requirement that the death penalty first proves itself to be a truly deterrent factor in criminal behavior. If there was a dramatically higher incidence of criminality during the time that the death penalty was suspended, that there would have been the need to prove that the death penalty was indeed a deterrent during the years that the death penalty was suspended. Here, the Supreme Court was so clear, Madam Speaker, in the recitation of the history of death penalty, and in my experience as a litigator, I recall that 1935 Constitution allowed death penalty, as in fact a lot of accused. I recall, in fact, when I was a student in Ateneo, the case of Maggie de la Riva. 4 scions of wealthy families in Manila were executed because of the crime of rape. Now, there came 1987 Constitution, which attempted to abolish death penalty. But a review of the recitation of the facts that ensued would show that death penalty was never abolished. It was merely suspended, and Section 19, Paragraph 1, Article 3 of the Constitution is quite clear on that. Death penalty was prohibited but then subject to an exception that for compelling reasons on heinous crimes, Congress can have it restored. I hope I answered faithfully the question of the Honorable Delmar.
I'm afraid not, Mr. Sponsor, Madam Speaker. But I will not belabor this point since this has been adequately discussed by the Honorable Lagman and the Honorable O'Malley. But from my reading, Your Honor, Mr. Speaker, from the provision, whether it's suspended, whether it's abolished, the fact is there was no death penalty provided in the new Constitution. Is it not correct?
Your Honor, the law is quite clear. Let me read it. Section 19, paragraph 1. Excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless, for compelling reasons involving heinous crimes, the Congress hereafter provides for it. If death penalty was abolished, there could have been no exception for compelling reasons involving heinous crimes.
We see the provision in different light, Your Honor, Madam Speaker. As I quote again that phrase, neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. Let us point to the line, neither death penalty shall be imposed. If there was already a death penalty imposed, this is no longer needed. It says, shall be. Neither shall death penalty be imposed. That is a future act, and it can be done only by Congress and not through the provisions of the Constitution. If Congress does not provide of it, then it will not come to pass. And here, it's supported. What I'm saying is supported by the Congress. Hereafter provides for it. Again, hereafter provides for it. It's not provided, so it's a future act that is required. The Congress will provide for it in the future, and the death penalty shall be imposed in the future. And one more line, Your Honor, Madam Speaker. The last line of this provision: any death penalty already imposed shall be reduced to reclusion perpetua. If there had been a death penalty already existing, then this death penalty would not be reduced to reclusion perpetua. Is that not so, Your Honor, Mr. Speaker?
Your Honor, with due respect, the nitpicking reply of the Honorable Delmar is somehow a reply or a manifestation that I cannot understand. Section 19, paragraph 1 says, death penalty shall not be imposed unless for compelling reasons involving heinous crimes, Congress hereafter provides for it. Again, if it was abolished, that abolition will not be subjected to any future or supervening event. We cannot be deliberating here over a death penalty if such has not been allowed in Section 19, Paragraph 1 of Article 3 of the Constitution. We precisely are here, just as the previous Congress passed the Republic Act 7659, because such was allowed in the Constitution, and the case of Leo Echegaray, decided by the Supreme Court in Bank, is proof that, Your Honor, Congress can pass a law on death penalty because it is so allowed as an exception under Section 19, Paragraph 1, Article 3 of the Constitution.
Your Honor, Madam Speaker, this representation certainly is not a nitpicker, Your Honor. Let our colleagues be the judge of who is nitpicking. But my last point here, Mr. Honor, to support the fact that it was no longer existing, is the word to impose, for the purpose of imposing the death penalty, to impose. If it was there already, the word should have been to resume. Would that be the case, Your Honor? It's very clear. We refer to the decision in the case of Leo Echegaray, but what better provision is more important and more credible and more believable, and there is no doubt whatsoever in necessarily resorting to support otherwise in a decision of the Supreme Court? Why don't we just look at and read the particular provision, which is very clear, Your Honor, Madam Speaker? But let me, as I said, we can go on, and as you advance an argument on your point, I will also advance another argument and reply to your position. So let us no longer belabor that. We have other things to discuss. Since I'm only entitled to 1 hour, 1 hour is it? When did I start so that I can be guided, Madam Speaker? Or again, I don't think, Madam Speaker, I hate to trouble you already because you will not know, and even our stenographers will not know without referring to the records, and it will take time to go into the records. The clock is the entire question and answer. We are only referring again to what Honorable Lagman stated, and which was accepted by your honors. And you did not question it, that it will be limited only to the time when the interpellator is addressing his questions and excluding the answer of the sponsor to the questions asked. Isn't that true? Isn't that, can I confirm that we're with the sponsor, Madam Speaker, Your Honor?
Majority Leader.
Madam Speaker, Your Honor, the lower portion of the clock indicates the amount of time consumed by the current speaker, or in this case, the interpellator, who is the Honorable Delmar. It begins once he is recognized by the chair. The appeal to the ruling of the chair that the time represents the 1 hour referred to in the rules. An appeal was made by the Honorable Lagman. It was put to a vote and it lost. Therefore, the clock shows, and it is still running because it is the time of the Honorable Delmar, which he has chosen to use by raising this point of order, is that he has consumed 29 minutes, visible on both sides of our hall, also at the rear of the hall. So he has 31 more minutes according to Section 91 and as voted upon by the body.
Time is running, so that includes the statement of the Majority Leader?
including your statement now, Your Honor.
Okay. I'm not about to argue on those.
Anyway, Madam Speaker,
Okay, let me go.
I have not responded yet to the point of the interpellator to
Good,
close
good.
the topic of whether or not death penalty has been abolished by the Constitution. Let me read into the record the decision of the Supreme Court in Bank in GR number 117472, February 7, 1997, People of the Philippines versus Leo Echegaray. Here the Supreme Court said, quote, "The import of this amendment," meaning Section 19, Paragraph 1, Article 3 of the Constitution, "the import of this amendment is unmistakable. By this amendment, the death penalty was not completely abolished by the 1987 Constitution. Rather, it merely suspended the death penalty and gave Congress the discretion to review it at the propitious time. Republic Act 7659 came into the picture and was ruled upon by the Supreme Court in Echegaray. Now we have House Bill 4727, which attempts, Madam Speaker, to revive the repealed Republic Act 7659 with a certain amendments, of course.
Again, Your Honor, Madam Speaker, I refer to the provision in the Constitution itself, which is paramount to any decision of the Supreme Court on the matter. So let...
Madam Speaker. Madam Speaker. Madam
The
Speaker.
gentleman, Majority Leader.
Just a point of information. I was watching the clock. When the Honorable Veloso started to make his answer, it was 30 minutes. When he ended his answer, the clock recorded 31 minutes. So, the time consumed by the distinguished Veloso was counted. Not only the time consumed by the distinguished Congressman Raul Del Mar. So that clock records for the information of everybody both the time consumed by the interpolator and the time consumed by the answering sponsor.
Including the time of the Honorable Lagman, I guess, also.
Yes, including my time. Now that I'm speaking was recorded. So,
Precisely, Madam Speaker. It begins once the interpellator is recognized. So it includes his question and as voted upon the answer. And if the interpellator will allow any sort of discussion, such as the time I am taking now, it will also eat into his 1 hour. So for those that seriously want to interpellate, I do believe that they should take advantage of their 1 hour, not allow any distractions to take place, so that they can maximize their interpellation of the sponsor. Madam Speaker.
Noted, Majority Leader.
Madam Speaker, it's good that the distinguished acting Majority Leader has recognized that the clock records all of the proceedings, the interpellation, the answer, and even some intervention from the floor. So I was saying earlier that the 1 hour under the rules should be limited to the time consumed by the interpellator, not including the answers of the sponsoring committee.
I beg the indulgence of the gentleman whose time is being consumed, if I may be allowed to respond, because it is his time and it is being consumed. But by way of response, Madam Speaker, this precisely was your ruling, Your Honor, that the 1 hour includes the totality of the time beginning from when the interpellator is recognized. It was put to an appeal and it was voted down by plenary. The decision of the body is that the 1 hour, as found in our rules, includes all of these discussions. So I will not take any more of the time of the Honorable Delmar so that he may continue his interpellation, Madam Speaker.
That
Please
was
proceed,
not the
Honorable
essence
Delmar.
of the result of the voting, Madam Speaker.
Noted. Please proceed if you would like to proceed, Honorable Delmar.
Madam Chair, parliamentary inquiry. May I be recognized, Madam Chair?
Yes.
Thank you, Madam Chair. Madam Chair, I would, since the matter at hand concerns a ruling of the Chair and the apparent interpretation of the distinguished Deputy Majority Leader is that your ruling, or the Chair's ruling, is that the 1 hour of the interpellator referred to in our rules includes the answer given by the sponsor as well as the other interventions. Then I think that would be an untenable.
The gentleman cannot rise because he has not raised a point of order. The gentleman has the floor. He cannot interrupt the interpellation. So if there is no point of order, he should not be recognized, Madam Speaker. I think he's making an inquiry or a manifestation. He cannot. There is an interpellation going on. So unless the gentleman has a point of order, I pray that the Speaker will not recognize him.
It's a very valid point. Please, Congressman Delmar, would you like to proceed with your interpellation?
Of course, Madam Speaker. Your Honor, I don't know if you're aware that there is now a new concept of heinous crimes. And nowhere in the definition and enumeration, Your Honor, Madam Speaker, was there any reference to this new concept of heinous crimes, which is now limited to grievous offenses like genocide or international terrorism, where great masses of people are killed or when the security of the state is endangered? Are you aware of this, Your Honor, Madam Speaker?
Your Honor, Section 3 of House Bill 4727 defines heinous crime. It says, the death penalty is hereby imposed on crimes under this Act as heinous for being grievous, odious, and hateful offenses, which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized, and ordered society. Madam Speaker, this was lifted from the ruling of the Supreme Court in People versus Echegaray. It is not a new definition. This is an old definition, Madam Speaker.
I will no longer comment on that, Madam Speaker, Your Honor, because my time runs even when the sponsor is the one talking. So let me proceed. While the bill enumerates the crimes for which the death penalty is to be imposed, the list is flawed because of the lack of a clear definition of heinous crimes. I think I already mentioned that, Your Honor. So let's go now to the second requirement of compelling reasons, which was discussed, but this is very important because, Your Honor, Madam Speaker, if the requirement of heinous crimes and compelling reasons is not met, this bill is unconstitutional. We don't even need to discuss this further. If we find, after discussions on heinous crimes and compelling reasons, therefore, that it does not satisfy the requirement, the provision, the conditions required in the provision of the Constitution, then that's the end of the ball game, Madam Speaker, Your Honor. But don't answer that anymore because you will consume my time, Your Honor. Well,
Let's now go to the second requirement of compelling reasons
Your Honor,
involving heinous crimes.
I don't
The
think
compelling
it-
reasons for each and every heinous crime enumerated here must also be clearly shown. The bill does not provide the compelling reasons for the imposition of the death penalty, but merely according to the according to sponsor Umali, his four compelling reasons which he delivered in his speech. That does not suffice and adequately meet the requirement of the definition of compelling reasons, because there must be a compelling reason justifying the imposition of each and every crime enumerated, not a general and collective compelling reasons which do not refer to, which refers to the death penalty but does not refer to any of the crimes which are enumerated and categorized as heinous crimes just because they are so included in enumeration. And that is why this is very ambiguous and arbitrary, because if the sponsors would desire to add another 10 to the 21 crimes, then 31, nothing is there to stop them, Madam Speaker, Your Honor. If we do not require specifically giving an explanation or statement justifying the compelling reason for each and every crime enumerated to justify the imposition of the death penalty. Your Honor, Madam Speaker.
Your Honor, heinous crime is defined in Section 3 as it was so defined in 7659 because of the character of the crime committed and because, according to the Supreme Court in Echegaray, because of the result of the criminal act. Let me explain, Madam Speaker. The Supreme Court in Echegaray said, the death penalty is imposed in heinous crimes because the perpetrators thereof have committed unforgivable, execrable acts that have so deeply dehumanized the person, or criminal acts with severely destructive effects on the national efforts to lift the masses from abject poverty through organized governmental strategies based on a disciplined and honest citizenry, and because they have so caused irreparable and substantial injury to both their victim and the society, and the repetition of their acts would pose actual threat to the society, to the safety of individuals, and the survival of government, they must be permanently prevented from doing so. In the end, Madam Speaker, the Supreme Court said, otherwise put, to ask what the rights are of the dying is to ask what the rights are of the living, unquote. So I don't think House Bill 4727 is deficient in describing to the honorable gentleman what a heinous crime is.
Madam Speaker, Your Honor, let me not enumerate because I will run out of time, but merely state that the 21 crimes referred to and categorized as heinous crimes just because of the imposition of the death penalty, which is not in order, as they are enumerated from page 2 to page 16 or 15. All 21 crimes. Let everyone go over the bill, and you will see that as they are enumerated, there is nothing. It's merely enumeration. There is nothing to justify, no description, no definition that these are specifically, each and every one of these are heinous crimes, and there is compelling reason for imposing the death penalty. In view
of that lack of requirement, Madam Speaker, Your Honor, definitely this does not satisfy the constitutional provision and is therefore unconstitutional, Madam Speaker, Your Honor. So let me move on to other points which I'm limited to only some points with 15 minutes left. The sponsorship speech of sponsor O'Malley last night had very disturbing statements and questions. My questions, he said, extrajudicial killings or death penalty? Making us choose. Meaning if we don't approve this death penalty measure, then we will have extrajudicial killings. So it's not choosing between extrajudicial killing or death penalty. None of the two. In other words, none of the above. And second, he mentioned here again that rising criminality or death penalty. Again, we don't want rising criminality nor death penalty. And third, that I can recall is death without due process or death after due process. Again, not to any two of these. So there is very disturbing, Your Honor. And he has a statement here, and I'm surprised for a very brilliant lawyer to make that observation that he practically trying to convince us that crimes should not be only through gauging proof beyond, requiring evidence, proof beyond reasonable doubt. He said, it must be remembered that the cornerstone of our criminal justice is the presumption of innocence. Proof beyond reasonable doubt is necessary in conviction. In this regard, our justice system is geared and skewed in favor of the accused. All the accused are not automatically subject to conviction. Would he wants to change the criteria for the evidence required, which is proof beyond reasonable doubt in criminal cases to preponderance of evidence like in civil cases, Your Honor, Madam Speaker?
Your Honor, this is a criminal aspect of our judicial system. We are governed by the quantum of evidence, proof beyond reasonable doubt. I do not have to remind the Honorable Del Mar, who is a brilliant lawyer from Cebu, that preponderance of evidence will apply only in civil cases, just as in administrative cases, as provided for in Section 5, Rule 133 of the Rules of Court. It requires only substantial evidence. But let me go to the point, Madam Speaker. As earlier read into the records, quoting the ruling of the Supreme Court in Chekaray, it is immaterial and irrelevant that Republic Act number 7659, the forerunner of House Bill 4727, cites that there has been an alarming upsurge of such crimes, for the same was never intended by said law to be the yardstick to determine the existence of compelling reasons involving heinous crimes. One heinous crime, Madam Speaker, would be enough for the imposition of death penalty. We do not have to go to the data demanded from the PNP. Fittingly, thus, what Republic Act number 7659 states is that, quote, the Congress, in the interest of justice, public order and rule of law, and the need to rationalize and harmonize the penal sanctions for heinous crimes, finds compelling reasons to impose the death penalty for said crimes. It is, therefore, the prerogative of this chamber, Madam Speaker, to come up with laws classified as heinous crimes as to character and the effect inflicted upon the victims, Madam Speaker.
Thank you, distinguished sponsor, Madam Speaker. With only 10 minutes left, I have only a few questions that I'm entitled to ask. So let me just go through my questions by merely statements so that I can cover more ground, Your Honor, Madam Speaker, if I can. This representation does not agree with the sponsors saying that there is a material correlation between death penalty and the lowering of crime rate. There is no clear study which reveals a material correlation between death penalty and the lowering of crime rate. So it is safe to conclude that capital punishment is not a necessary deterrent to crime. In 1999, President Joseph Estrada carried out the capital punishment and put to death 7 convicts. It was a bumper year for executions, which were intended to abate criminality. Instead, using the same year as baseline, criminality increased 15.3%, or a total of 80,538 crimes from 70,527 crimes in the previous year. And neither is the alleged rising rate of criminality a compelling reason for the following grounds. Statistics from PC and NP and now PNP show that there is in fact a decline in the crime rate after 1987. Based on the data provided by PNP, in the years after the abolition of the death penalty, crime volume has been decreasing. For the period 1990 until 1993, crime rates for murder and robbery show a consistent decrease year by year. During the year 2000, when a moratorium on executions was declared, total crime volume, which was 80,108, decreased by 2,430 compared to that of 1999. There are other, the only item that I agreed with the sponsor last night was the need for improving and making more efficient our criminal justice system. So it is not the death penalty. It is the improvement and the efficient criminal justice system to make sure that the criminal does not, he says, it is for fear of the death penalty that deters a criminal from committing criminal acts. It is not, Madam Speaker, Your Honor, it is the certainty of arrest, prosecution, conviction, and jail. And again, the sponsor said that death penalty or the mess that the believed in prison is undergoing. Not all jails are like that. That is a special case. That jail of with 5-star accommodation and principal office of the convicts to operate their criminal activities. That is a very isolated case, Your Honor. That is not meant to happen. If we will improve our justice system, the necessary correction in the penal system will also be made. So it is not just death penalty that we need. It is a complete overhaul and improvement of the criminal justice system. And
may I respond to that before I get lost?
Okay, that's all right. Of course, Your Honor, Madam Speaker.
I respect the opinion of the Honorable Dilmar, but let me just read into the records what the Supreme Court held in Chagaray. Supreme Court said, quote, "The abolitionists in Congress insisted that all criminal reforms must first be pursued and implemented before the death penalty be imposed in case such reforms prove unsuccessful. They claimed that the only compelling reason contemplated of by the Constitution is that nothing else but the death penalty is left for the government to resort to that could check the chaos and the destruction that is being caused by unbridled criminality. Three of our colleagues are of the opinion that the compelling reason required by the Constitution is that there occurred a dramatic and significant change in the socio-cultural milieu after the suspension of the death penalty on February 2, 1987, such as the unprecedented rise in the incidence of criminality. Such, take note, Madam Speaker, this is what the Supreme Court said, such are, however, interpretations only of the phrase, quote, compelling reasons, unquote, but not of the conjunctive phrase, compelling reasons involving heinous crimes, unquote. We are members of the bar. We have no choice but to follow the interpretation of the Constitution. Yes, we can disagree with the Supreme Court, but the Supreme Court is supreme, even presumptively in its errors, especially in this case, that the Supreme Court did not err in coming up with the interpretation that there is really no need for us to reform the criminal system we have before we can impose death penalty.
The Speaker, Your Honor, let me proceed with an equally general statement in view of the limited time. The laws that are already enumerated are punishable already by reclusion perpetua or life imprisonment. I believe that the sponsors doesn't consider life imprisonment harsh enough. But if the convicts will not be entitled to the excellent condition in Bilibid, this is the general rule. Now, I believe, Your Honor, if you think about life imprisonment, that you will shudder at the thought of any one of your friends or family members suffering the same. Because we, all of us colleagues here, are confined to our homes and not mobile and not free to roam when we're sick. But when we get well, we cannot be prevented, or we will suffer if our movement or free will will not allow us to go out, even out of our air-conditioned homes or our air-conditioned rooms. Think of the prisoner. Not only a day or two, months, years, 30 years, 40 years. Do you think that anyone will not get crazy being isolated or imprisoned, Your Honor, that you think lightly of life imprisonment?
Your Honor, that is what the gentleman believes as enough penalty for heinous crimes. But unfortunately, Madam Speaker, Section 19, Paragraph 1, Article 3 of the Constitution gave Congress the prerogative to penalize the heinous criminals, criminals that commit criminal acts categorized as heinous crimes. Again, we are here not to isolatedly, Madam Speaker, discuss what we believe personally, but what the Constitution says, what the Supreme Court has interpreted it to be, and exactly as I said, the House Bill 4727 is designed to resuscitate Republic Act 7659.
Okay, another point in the sponsorship speech of Chairman O'Malley, he said that many might fear the ire of religious groups and loss of votes from their constituents who are so-called pro-life and against death penalty. So it's either, he's making again choose whether we will be pro-life or death penalty. Is there any difficulty there? Of course, we are all pro-life, pro-God, pro-people. And we never go for death penalty. But this is a very disparaging remark that we don't support death penalty because we are afraid of losing the Catholic vote. I guess that is unfair, Madam Speaker, distinguished sponsor, to everyone in this hall, every member of this chamber. Most religions in the world condemn the death penalty. Ours, a predominantly Catholic country, is expected to shun the capital punishment. After all, Madam Speaker, Your Honor, law is the will of the state, which in turn is shaped by the beliefs of its people. So we should not begrudge the involvement of the church. The church and the state are partners, share a common objective. Our crime is our common enemy. So even the Ten Commandments and all religious teachings, if you compare them with our laws, are geared towards the same objective, the same values. So we should not look upon the Catholic Church as villains here. We should thank the Catholic Church for being there to help the state make people live up to moral values and deeds that are really being admired.
Madam Speaker, Madam Speaker, a very serious matter is being discussed on the floor. And indeed,
Madam Speaker, can I first respond to that?
Leader.
After all, there has been no point of order question raised.
we are questioning the quorum, Madam Speaker. That's primary, because we don't have enough members listening to the two gentlemen.
May
We
I
are
just
questioning
first
the
respond
quorum.
to
We
the
move for
interpellation,
adjournment.
Madam Speaker, before we discuss the
Majority
quorum
Leader.
issue?
Madam Speaker, we
before that,
appeal to the Honorable
can
Atienza
you
to
let me
allow the
finish?
sponsor to
Majority
Can you
Leader.
let me
Finish the
finish
interpellation
on
first.
that issue?
The question of quorum should not be debatable. It should be established. If the gentleman on the floor would like to continue, they should assert that establishing the quorum is primary. Otherwise, we are not going through the rules anymore and following the rules. We keep on violating it in a very critical question, like reimposing the death penalty.
Majority Leader.
Madam Speaker, ours is simply an appeal to the Honorable Atienza, noting that we in the majority are in cognizance that the Honorable Del Mar has consumed his full time and has gone beyond the limit, but we are willing, in the spirit of debate, to allow them to, the sponsor and the interpellator, to finish their debate because of the matter at hand. So even though that the 1 hour has been completely consumed, so we appeal to the Honorable Atienza, aside from our Honorable
I beg
Del
to
Mar,
disagree, Your Honor, Madam Speaker. My hour has not been fully consumed.
For the record, Madam Speaker, the clock shows 1 hour, 4 minutes, and if I may continue, Madam Speaker, there are a number of our colleagues.
Again, you're including your statement and that of the gentleman from Manila.
Madam Speaker, I am trying to get more time for the gentleman.
It's all right to include the time taken
Majority.
by the sponsor to answer the question, but for you to include the question of point or order of quorum on the part of the gentleman from Manila and your reply and added to my time, and you say my time has already expired, is, I think, unfair, Your Honor, Madam Speaker.
Madam Speaker, please let the debate continue.
Madam Speaker, before we continue the debate, we insist on adjourning because we do not have enough members on the floor anymore. Why are you rushing it? What's the point? We can continue tomorrow if you would want to call for a special session.
Just a
When
few
there is a
seconds,
quorum.
Madam Speaker. I will just answer the interpellation of the Honorable
With the
Dilmar.
assurance that he will just answer, we withdraw our motion momentarily.
Before the answer, Your Honor, Madam Speaker, let me finish the statement.
Akala ko tapos na yon.
Di pa.
Please proceed,
Okay.
Congressman Delmar.
Does the death penalty fall within the set of beliefs of the majority of our people? Catholics also believe in retribution, but not by taking human life. The eye for an eye injunction in the Old Testament has long been replaced by turn the other cheek advice in the New Testament. Catholics and other Christians believe in repentance and the capacity of sinners to reform. The death penalty totally rejects that possibility. When the death penalty was abolished in this country, the state recognized the sentiment of the dominant sector of the population. This Catholic Bishops' Conference of the Philippines then noted that it also as a recognition of the dignity of human life. Are we now retracing, Madam Speaker, Your Honor, our steps from that phase in our moral and progressive development as a nation?
Madam Speaker, in my sponsorship speech yesterday, I pointed out that we are not establishing enmity with the Church. I said House Bill 4727 is not being anti-God. I have here a reproduction of the book published by command of Pope Pius V, the Catechism of the Council of Trent. And, Madam Speaker, this was published in English by Reverend J. Donovan. Here, no less than Pope Pius V said that the fifth commandment, thou shalt not kill, is not inclusive. It is not without exceptions. And here, Pope Pius V said, thou shalt not kill will not apply to situations where you kill an animal. It will not apply to a situation where a soldier is killing an enemy in a just war. It will not apply in a situation in cases of accident. It will not apply in instances where you kill by reason of self-defense. And more importantly, it will not apply if a person is being killed on account of an order of a civil magistrate. Let me read, Madam Speaker, what Pope Pius V explained. Again, this prohibition does not apply to the civil magistrate to whom is entrusted the power of life and death, by the legal and judicious exercise of which he punishes the guilty and protects the innocent. The use of the civil sword, when wielded by the hand of justice, far from involving the crime of murder, is an act of paramount obedience to this commandment, which prohibits murder. The end of the commandment is the preservation and security of human life, and to the attainment of this end, the punishments inflicted by the civil magistrate, who is the legitimate avenger of crime, naturally tend, giving security to life by repressing outrage and violence. Hence the words of David, quote, in the morning I put to death all the wicked of the land, that I might cut off all the workers of iniquity from the city of the Lord. It is therefore a lie for anybody from the church to claim that the mandate of Vatican is not to kill a criminal who committed acts categorized as heinous crimes if it proceeds from an order of our courts. I hope that answers fully the point
We
of the
already
Honorable
listened to the answer of the honorable sponsor. We reiterate our motion now to adjourn because we even see less people on the floor than earlier. We cannot continue listening to a discourse on the doctrinal teachings of our church, although distorted, when we do not have a quorum anymore. We move for adjournment.
Majority Leader.
Madam Speaker, Your Honor, again, our appeal to the honorable colleague. There are a number of our colleagues who have been waiting the whole afternoon and evening to debate this. Will you allow them to have their say? Madam Speaker.
Continue listening to a continuing insult to the Catholic Church. Madam Speaker, we are questioning the quorum. We move for adjournment.
Majority Leader.
I take exception, Your Honor, to that remark because I am not insulting my own religion. I am a devout Catholic. I receive communion every day. And I cannot receive Christ in my body if I am despising my church. Let it be on record. And I will not tolerate the Honorable Atienza to cast me as an enemy of the church.
Neither will I tolerate an insult to my faith. He is misinterpreting the papal doctrine on killings. Yan po ang totoo niyan, to serve his purpose, and therefore I move for adjournment.
Madam Speaker, the Honorable Atienza is not interpolating me. I just cited what Pope Pius V said in the Catechism Council of Trent. You can check that from the internet.
Majority Leader.
Madam Speaker, if the Honorable Atienza will kindly lay aside his motion for a few minutes, I would move for the approval of the journal with his consent. Madam Speaker, I thank the Honorable Atienza for his kind indulgence. I move for the approval of Journal number 66, dated Feb 6, 2017, and Journal number 67, dated Feb 7, 2017. So move, Madam Speaker, Your Honor.
Is there an objection? Hearing none, the motion is approved.
Madam Speaker, we second the motion of the Honorable Atienza to adjourn till tomorrow, Monday, February 13, 4 o'clock in the afternoon. So move, Madam Speaker.
Hindi ba? Oo nga eh.